Hello, and thank you for joining us for the ABA Commission on Immigration's presentation on Asylum 101 for the family group dedicated docket. My name is Deena Sharuk, and I'm a senior legal advisor to the Commission on Immigration. Today's presentation is a broad overview of asylum with a specific focus on representing asylum seekers on the family group dedicated docket. The dedicated docket was announced on May 28, 2021, and it's specifically dedicated to adjudicating family cases before the Executive Office for Immigration Review. These cases are selected and placed on the dedicated docket, where immigration judges from the Executive Office for Immigration Review will work to issue a decision within 300 days of that initial master calendar hearing. That 300 days is an internal goal and not a requirement. Track reports that cases have primarily come from Ecuador, Honduras, Brazil, Guatemala, Nicaragua, Haiti, El Salvador, Venezuela, Cuba, and Mexico. Today's presentation is going to cover the definition of asylum and the benefits that one receives if granted asylum, eligibility for asylum, as well as the process for applying for asylum for respondents on the dedicated docket. Finally, we'll be discussing some resources that one can review in preparing an asylum application and submission. So what is asylum? Asylum is a form of protection offering refuge to individuals fleeing persecution on account of certain protected grounds. The benefits of asylum include that one can remain in the United States. It bestows derivative status on spouse and unmarried children under the age of 21. It's also a pathway to citizenship for the asylee and any derivative asylees. It grants permission to work, including receipt of the Social Security card. And it also gains access to certain forms of government assistance, such as financial assistance, medical assistance, English language training, and employment training and placement. So let's talk about eligibility for asylum. A non-citizen in the United States who meets the definition of a refugee is eligible for asylum. And specifically, a refugee is a person outside of their home country who's unable or unwilling to return to their home country because of persecution or a well-founded fear of persecution on account of their race, religion, nationality, membership in a particular social group, or political opinion. That definition can feel a bit cumbersome, so let's break it down to the elements of asylum. The burden of proof is on the applicant to show that they're in the United States. And you must be in the United States, but you can also request asylum at the border, but you cannot claim asylum abroad. That person also has to be unable or unwilling to return to their home country. Someone is unable to return to their home country when they are, say, stateless or have had their passport revoked, for example. Most asylum seekers will fall into the category of being unwilling to return to their home country due to a well-founded fear of persecution. And that brings us to our third bullet, well-founded fear of persecution or having experienced past persecution. And that persecution has to be on account of one of the protected grounds. And that would include race, nationality, religion, political opinion, or social group. And we'll get into the definitions of those protected grounds shortly. It's important to note that asylum is discretionary. So just because you're eligible for asylum does not mean that you are going to receive asylum. And finally, somebody who is eligible for asylum cannot be subject to some of the bars to asylum. And we'll get into what some of those bars are shortly. Unfortunately, there is no precise definition of persecution. Generally, persecution involves serious harm or a threat of serious harm or even death. Some acts may constitute persecution depending on the severity, frequency, and cumulative effects of those acts. And some acts in the aggregate constitute persecution. Generally, persecution is decided on a case-by-case basis, so it's advisable to look for cases that are analogous. Cases from the Board of Immigration Appeals, or the circuit in which you are representing your client, or even the Supreme Court may shed light on whether or not your client has suffered persecution or fears persecution. Just a note on the persecutor does not have to be the state or government. It can be an individual or another group who the government will not or cannot control. It's important, regardless, to show that the applicant has nowhere safe to go in home country. And we'll talk more about that shortly. One of the best ways to demonstrate a well founded fear of future persecution is that your client has actually experienced past persecution. In fact, when somebody establishes past persecution, they create a rebuttable presumption that they have a well founded fear of future persecution. To rebut that rebuttable presumption, the Department of Homeland Security would have to show by a preponderance of the evidence that there has been a change of circumstances that would show that the persecution will not happen again in the future, or that the applicant has an internal flight alternative. And that really means that they could internally relocate their way to safety. It's just important to note that the presumption is that if you have a government persecutor, there really is no safe internal relocation. And internal relocation really has to be reasonable. It's not that it would be reasonable for somebody to live the rest of their life in a bomb shelter. It has to be reasonable given that person's experiences and access to resources and abilities. So let's talk a little bit about the nexus or on account of element of asylum. It's one of the more difficult parts of the asylum claim to prove because persecutors don't usually write emails that say, I'm coming to persecute you because of your political opinion. That being said, it is a provable element in asylum claims, and it's usually proven through behavior, acts, patterns, and sometimes communications. And this can be critical in proving a persecutor's intent. Sometimes you have concerns because a persecutor may have mixed motives for persecuting the asylum applicant. And the way to handle that is really to demonstrate that the membership in one of those five protected grounds is at least one central reason for the persecution. The idea of one central reason really being that reason can't be incidental, tangential, superficial, or really subordinate to any other reasons for the persecution. You can also have cases where there are multiple theories of the case or multiple protected grounds as the impetus for the persecution. And that's fine so long as any one of those protected grounds is the central reason for the persecution. Finally, you should really be aware of concerns that a judge may have about civil wars. If your client is coming from a place where there's civil strife or just general unrest, a concern might be that the conditions on the ground are just terrible in general, and your client isn't really suffering persecution because of their membership in any of those protected grounds, but because they're just simply collateral damage. And by building a strong nexus argument, you can evade any of those kind of civil war concerns. Moving on to the protected grounds. The first is race. And race and religion can be a bit more straightforward in terms of what they are as a reason for persecution. An example could be a Black or Afro Brazilian asylum seeker. The second is religion. As we said, it's a bit more straightforward. Third is nationality, and that can also be used to include ethnic minorities, tribes, and indigenous peoples. That can be particularly relevant in the Latin American context. For example, the Garifuna indigenous people in Honduras. And a lot of these protected grounds can be intertwined. So, for example, the Garifuna are mixed indigenous and African in origin. So, in a case where you're dealing with somebody suffering persecution for being Garifuna, it might be unclear if it's due to being indigenous or of being of another race. You can present both theories as a central reason. You can also present both theories as alternatives. It was either because they are Garifuna or present as Black. There really is no limit on how many theories of your case that you present, but you will want to be cognizant of diluting your strongest arguments if you're trying to throw whatever at the wall to see what sticks. So, moving on to the protected ground of political opinion. Circuits are split on the definition of the political opinion, so you'll want to research the definition in your circuit. Political opinion cases don't have to include the classic political dissident. An applicant could have a political opinion about anything. This could include feminist views about roles and relationships, or criticism of government handling of economic collapse or government handling of the pandemic. You'll want to think broadly about how your client's political opinion has been expressed or made visible. For example, under Fourth Circuit case law, symbolic acts as well as direct speech or actions may be construed as expressions of a political opinion. Circuits are also split on the concept of neutrality as a political opinion. So that's something you'd want to research if you had a client who fell in that category. It's important to be cognizant of the fact that imputed political opinions are also valid. So, an individual who has a political opinion attributed to them, even though if they don't truly harbor it, if they're being persecuted on the grounds of that imputed political opinion, they still have a claim for asylum. Please note that other grounds of asylum can also be imputed, for example, imputed race, religion, or nationality, but the case law is not necessarily as well established as it is in the political opinion arena. So moving on to social group. And this is actually one of the more complex of the protected grounds. There are three prongs to establishing a cognizable social group. The first is having an immutable characteristic, and that's something that one cannot change or should not be expected to change. For example, one's gender identity. Next is being socially distinct or social visibility. And that is that that group is identified and recognized as a collection of people in that society. And finally, there's the particularity prong. The group cannot be amorphous. You're either in or you're out, and the lines have to be well defined. For example, wealthy Guatemalans isn't well defined. There's a real question of what really makes somebody wealthy. When working with the social group, you'll want to consider cases that have already been deemed as having cognizable social groups. If your client falls into and is being persecuted on the grounds of being a member of a cognizable and recognized social group, then it's generally a bit easier to make that argument than to construct a new social group. But you're working with the facts that you have before you. That's not to say that one cannot construct and argue for a social group that has not been recognized yet for the immigration court. Some examples of social groups include family groups. You might see this in family members of informants or people who have worked with a particular outside government, for example. If I'm being persecuted because I have a parent who is an informant, then I'm being persecuted on the grounds of my family group. Another example is gender or sex plus another attribute. Doing simply a gender based case when talking about cisgender, so being persecuted on the grounds of being a woman, for example, that can be a bit tricky and it's best paired with another attribute. So Guatemalan women, by all accounts, should be considered a social group. It's socially distinct, particular, and immutable, but there are always these kinds of unfounded concerns with respect to social groups broadly, but cisgender social groups having that concern about the floodgates being opened so that all Guatemalan women would somehow now have an asylum claim. And that really is not the case because one, again, would have to show nexus to persecution. So, where possible, when dealing with somebody who's being persecuted on the grounds of their gender, if they're being also persecuted for another protected ground, you can construct the social group to strengthen the claim. So, for example, Brazilian indigenous women or Cuban women who support democracy, Haitian women missionaries. Although one should be careful with professions. You really want to maintain that particularity piece. So someone could quit a missionary job. The question when dealing with professions is really whether the title, in this case, missionary, ever leaves them in the eyes of the community. So they may have quit the job, but are they always going to be seen as the missionary and persecuted because of it? So, as we mentioned earlier, asylum is discretionary. It is not an entitlement. So, just because somebody is eligible does not mean that they will get asylum. There are many different factors that a judge will consider when deciding whether or not an applicant merits asylum. There are positive and negative factors. Some factors include manner of entry, relatives in the United States who have status. So, having relatives in the United States with status is a positive attribute. Seriousness of any fraud to circumvent immigration laws or crimes, having any kind of criminal activity outside of the bars of asylum, which we'll discuss shortly, any kind of humanitarian considerations like age or poor health. But you can be creative in the factors you present. If your client has negative factors, so for example, many folks on the, if not all, on the dedicated docket for family groups will have entered the United States between ports of entry. And that is a negative discretionary factor. But like I said, one should not simply throw in the towel because there's a negative factor. You can mitigate negative factors with positive factors. And this list is not exhaustive. Be creative in the factors that you present as to why your client really merits receipt of asylum. So there are bars to asylum, and this is really a broad overview. If you have concerns that your client is subject to one of the bars to asylum, you'll obviously want to conduct very thorough research on the subject and perhaps turn to your pro bono mentor for guidance. The first bar on this list is the firm resettlement bar. And the question here is whether or not your client had firmly resettled, having legal status to remain in another country. And that's a country second to their home country. And this question of firm resettlement is really a question about the quality of the relationship between the applicant and the country through which they moved rather than the duration of their stay. So if somebody is fleeing from Brazil and spends time in Mexico, the question is really whether or not they have legal status to remain in, say, Mexico. If they don't, and they cannot remain with any kind of level of permanency, then they should not be subject to the firm resettlement bar. Now, if they've been offered some form of status to remain in Mexico with some element of permanency, then there is a question of whether or not they really are fleeing to the United States because of persecution. Now, in a case where somebody is firmly resettled in a second country, the next question is whether or not they are being persecuted in home country as well as that second country. In that instance, they could claim asylum in the United States. The second bar to asylum is the safe third country bar. And safe third countries are designated by treaties. To date, the United States has only one valid treaty with Canada, and it precludes asylum for individuals who are not Canadian who enter the United States from Canada to seek asylum. The treaty is currently in flux on the Canadian side, but as of the date of this presentation, the treaty still holds. There were, during the Trump administration, asylum cooperative agreements with Guatemala, Honduras, and El Salvador, but the Biden administration has terminated and suspended those agreements as of the date of this presentation. The third bar in this on this list is the 1 year bar. And the 1 year bar is really quite important to note. It's that Applicants only have 1 year from their entry to the United States to apply for asylum. There are exceptions to this bar for people who can prove that they either had changed or extraordinary circumstances. Changed circumstances are ones where they were not necessarily fearing persecution in home country during the early stages of their entry, but subsequently and were able to apply after that 1 year bar. The second is extraordinary circumstances that prohibit them from filing earlier. An example of that might be a severe mental health ailments. The applicant, in a case where there are extraordinary circumstances or changed circumstances, still must apply within a reasonable time after those circumstances. So, in other words, applicants don't necessarily get a whole other year to apply. Examples of the exceptions are found in the regulations. As I mentioned, they may include physical or severe mental disabilities, or also very severe mental health issues that prevent them from applying within that 1 year limit. Also, youth. So, somebody who enters the United States under the age of 18, that would also be considered an extraordinary circumstance. The next few on this list include persecutors, folks who are engaged or support terrorism, people who engage in particularly serious crimes or serious non political crimes outside of the United States. With respect to crime, there are two bars for persons who have any kind of criminal convictions: those who have been convicted of a particularly serious crime, and those for whom there are serious reasons to believe that they have committed a serious non political crime outside the United States. It's worth saying at the outset that these criminal bars are extremely complicated, and we're only going to touch on them today. So, if you have a client who has a criminal history, you should research this area carefully and certainly turn to your pro bono mentor if you have questions. When we talk about particularly serious crimes, aggravated felonies are going to fall into the category of particularly serious crimes. But aggravated felonies are not necessarily felonies in the immigration context. Examples of aggravated felonies include trafficking in weapons or explosives, possession or trafficking of a controlled substance, illegal gambling and money laundering, crimes of violence for which the term of imprisonment imposed is at least 1 year, theft offenses where the term of incarceration is at least 1 year, and fraud. For particularly serious crimes, it doesn't matter if they have not been convicted. The question is whether or not they have committed any particularly serious crimes. And the seriousness is determined by considering factors such as the nature of the conviction, the type of sentence imposed, and the circumstances and underlying facts of the conviction. As an asylum bar, the term particularly serious crime has been statutorily defined to include all of those aggravated felonies, and the scope of the term aggravated felony has really greatly expanded in recent years. An applicant may also be barred for, as we said, having committed a serious non political crime outside the US, even if that crime is not an aggravated felony and the client has never been convicted. And finally, people who are seen as a danger to security of the United States or engaged in or provided material support to terrorist activities or terrorist groups can be banned for receiving asylum protections. That really includes any kind of support. And even if it is under duress, somebody can still be barred from receiving asylum. So now let's move on to the procedure for actually applying for asylum. And we're going to be focusing on defensive applications for respondents because they're on the dedicated docket. So if they are in removal proceedings, they should be applying for asylum defensively, and that's what we'll be discussing. But it's important to note that there is an affirmative process for folks who have permission to be in the United States and are not in removal proceedings, the exception to that being that unaccompanied minors have access to the affirmative system, the asylum office, while going through removal proceedings. In the case that your clients have their case dismissed from the dedicated docket, you should check in with your pro bono mentor regarding applying for asylum affirmatively if that is strategically the right decision for your clients. But as we said, because we're applying for asylum applications for families on the dedicated docket, you should be generally filing your application with the immigration court. So, as we said, because we are filing asylum applications for families on the dedicated docket, you should file your application with the immigration court where your client's case is being heard. And applications can be filed in open court or by mail or at the court at the filing window. When you file the court copy, you should also bring an additional copy for yourself to be stamped. And that stamp is proof that that asylum application has been filed and when it was filed. And that's really important when considering that 1 year bar. Anything that you file with the immigration court, a copy needs to be submitted to the Department of Homeland Security as well. So you would submit a conformed copy of all those filings to the ICE Office of Principal Legal Advisor, also referred to as OPLA, in that same jurisdiction. The form for filing the application is called the Form I-589, and it's available at uscis.gov. It's a 12-page form, and it has 14 pages of instructions. It's really important to review those instructions carefully. So, what really goes into the packet for asylum? You would include a cover letter to the court explaining what you are submitting and a table of contents for all that is in the submission. The Form I-589 is, as we said, that asylum application. And the EOIR 28, at this point, at this stage, should have been filed. But if it hasn't been filed, it's that notice of appearance for the attorney. It notifies the court that you will be representing these clients. And one should have an EOIR 28 for each individual family member. You can also submit a brief with your asylum application, and the details of the structure of a brief can be found in the EOIR practice manual that's also available online. The brief is your opportunity to put argument before the court ahead of your hearing and to clarify the matter at hand. And I have to say that the brief really is quite valuable, especially if you're dealing with a particularly complex case, if you have a particular social group that you're proposing to the court, if there is an imputed protected ground or concerns about Nexus, the brief really is the opportunity to make those arguments clear for the court. And surely it's quite important to submit evidence that supports your client's case. Evidence can include declarations, official documents, identity documents, proof of status, country condition reports, medical reports, psychological evaluations, photographs, news stories, text messages, audio recordings, etc. And it's really important to use evidence to demonstrate every element of your client's case. Sometimes evidence isn't available and one relies heavily on declarations and testimony, but anywhere that one can demonstrate that evidence is available, they should seek it out. And it's also quite important to demonstrate that if evidence exists but is unavailable for one reason or another, which frequently happens in asylum cases, it's important to demonstrate attempts to collect that evidence. And sometimes the inability to collect evidence that exists can be used as proof of the merits of one's case. For example, if a witness is fearful to present a declaration because they fear that they will be persecuted for helping your client, that in and of itself may be demonstrative of your client's legitimate fear of persecution in home country. With respect to evidence collection and corroboration, the burden is on the applicant to prove their credibility. Credible testimony and limited evidence may be enough to prove your client's case. But if evidence exists or can exist, it behooves you and your client to try to obtain it. It's important to use that evidence to prove every element of asylum eligibility. Everything that is submitted to the court needs to be submitted in English. If a document is in another language, one would have to include a certified translation. It does not have to be translated by a certified translator. It simply has to be translated by somebody who is competent to translate from the language of the document to English and sign a certification indicating such. Never submit any originals to the court because they become part of the record and your client may not get those documents back. You should certainly bring all originals to the court for the individual hearing, but original official documents should be submitted as a copy to the Department of Homeland Security and to the court. After filing the asylum application with the court, you would submit a copy of a portion of the application to USCIS in order for them to schedule a biometrics appointment for your client and any derivatives. The instructions for filing this portion of the asylum application are linked at the bottom of this slide. After submitting an application for asylum and receiving that biometrics appointment, you should note that that biometrics appointment can be rescheduled. The details of how to get it rescheduled will be listed on that biometrics appointment notice. You have an opportunity to submit any kind of supplemental evidence that becomes available at a later date. And the judge really dictates the filing schedule. Current guidelines indicate that one must submit any kind of supplemental filings 30 days ahead of the hearing. And in detained cases, it's often 10 days, although the judge's filing schedule reigns supreme. If you want more information about what to expect in an individual hearing, the ABA's Commission on Immigration has a webinar on the mechanics of immigration court that delves deeply into the individual hearing and what to expect. And speaking of resources, we have a list of a few resources that you may turn to in preparing your client's asylum case. The Commission on Immigration at the American Bar Association has several resources for representing clients on the family group dedicated docket. The Children's Immigration Law Academy has a wonderful pro bono guide, and the link for that guide is listed in this presentation in the notes for this slide. The AILA Asylum Primer is a really great primer on asylum, no less. And it is a great place to start in prepping one's case and getting into more of the nitty gritty of the law. Georgetown Law Library's Center for Applied Legal Studies Asylum Case Research Guide is also a wonderful resource for conducting research on asylum cases. UC Hastings Center for Gender and Refugee Studies is a really great resource in collecting any kind of guidance on gender-related cases. And the American Immigration Lawyers Association has resources for asylum as well. And as we mentioned earlier, the EOIR practice manual really is a very important manual to review before making any submissions and before going to the immigration court. Thank you for attending the American Bar Association's Commission on Immigration's presentation on Asylum 101 for families on the dedicated docket. Taking on cases for families in removal pro bono is really invaluable work. Thank you for doing so. If you have any questions about applying for asylum, certainly check in with your pro bono mentor. Thank you again, and be well.